case. While I agree with them that such an order would have been efficacious, in fact, the nature of this particular litigation being in the public interest, I would not grant the President orders of costs, despite my findings in his favor. On issue number 5, public participation by the IEBC and the initiators and promoters of the bill, I have looked at the BAT case, a recent decision of this court. I've also looked at Justice Pauline Nyamoya's judgment in Republic versus County Assembly of Kirinyaga, and I've agreed with the judge that in processes under 257, there are certain rules attributable to IEBC and to the initiators and promoters. Looking at the stage at which the IEBC was stopped, or the whole process was stopped, it is very difficult for me to say that public participation was not sufficient. In fact, the two most important public participation elements in a popular initiative are voter education by IEBC and popularization of the bill by the promoters. None of these processes had been reached by the time the High Court stopped the process. A last issue on this point is this. Gatembo, Kairu and Tuyot raised a fundamental question. Why are we as a country still struggling with lack of a legal framework to govern processes under Article 257? There is no law on collection of signatures. There is no law verification of those signatures. There is no law on how county assemblies should pass the amendment bill, the processes by Parliament despite the standing orders, the receipt of the bill by the President, transmission of the bill to the